All right, well, welcome everybody to another installment in the SOSV Webinar Series. Today we're talking about something that comes up all the time, basically anytime you start one of our accelerator programs. We've definitely sent you an email or two about this, but equity splits, and how to build a really profound and equitable relationship between founders. And so to talk about that with us today, I have Annie Weber, who's the CEO and founder of Legal Hero. And Annie, I'll let you introduce yourself, but essentially Annie comes to us with a ton of experience. She worked, before founding Legal Hero, she worked in private law. She has an MBA from Harvard. She has her JD from Harvard, so she's pretty smart. But Annie, I'll let you take it away, and then we'll jump right in.
Great. Thank you so much, Connor. Hi, everybody. It's nice to be here talking about such an emotionally laden subject as of co-founder equity splits. As Connor mentioned, my name is Annie Weber. I co-founded Legal Hero to just try to simplify the way businesses get legal help. We work with a ton of startups, and we work with founders at the very earliest stages as they're considering setting up their companies and how to do that. One of the topics, of course, that comes up is how do we split, who gets how much equity, and how do we structure that equity? It's something that most people, unless they are previously founded companies, don't really have experience with. So today what I'm going to do is just walk you through a short presentation and sort of give you some suggestions for exactly how to do that so that everyone is comfortable with the splits they take on. So I will just switch over to my presentation here. Great, so hopefully you all have up on your screens now the presentation titled Who Gets What? How to Split and Structure Co-Founder Equity. And we talk about splitting and structuring as two different things because, the split is the thing that people really like to talk about, 40%, 30%, 60%, 50-50, etc. It's the thing people get really sort of emotional about and amped up on. But structuring that co-founder equity is usually, just as important, and if not more important over time, because you can use structuring tricks to sort of affect how much of that equity eventually is actually fully vested and owned. So what I'm going to do is I'm going to walk through some of the structuring considerations that you might want to think about before we get to our sort of guidelines for how to split that equity. I have to mention, because I'm a lawyer, this is not legal advice, and it's not, it doesn't create an attorney-client relationship, yada, 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 legal mumbo jumbo. But I'm happy to take questions and chat with any of you individually. So first of all, what we're going to cover today is, first, this is a really awkward but very necessary conversation. Obviously, you're attending this webinar, so you're taking the first step toward having that conversation. I can't stress how important it is. So many co-founders sweep this under the rug because it's awkward, and that's a really bad place to start. Then we'll get into the structuring of the equity and the splitting of the equity. So here's what happens when people don't talk about the subject. If you don't structure and split equity carefully, you can end up with a lot of what we call dead equity. That means that a lot of people can be out in the world running around with your company equity that you could be using to incentivize current and future employees. And that's something nobody really likes. The other thing is resentment can factor in huge here if co-founders feel sort of slighted or like the world is unfair because an early co-founder has a ton of equity and walked away. These things, they honestly do lead to company failure. If you feel like you're not being compensated on the equity front, you can end up losing a lot of great talent. And of course, there's very famous litigation. Facebook, Snapchat are just two examples. But if the company does end up being hugely successful, you can end up with sort of a sideshow around co-founder equity. So having that conversation now prevents these problems down the road. So just moving into structuring equity, I think you've all heard of vesting. A lot of folks don't really understand how it works, so I figured it would make sense to give a small primer. So vesting, this is the legal definition you see up on the screen. It's just the process by which a founder accrues non-forfeitable rights over stock, meaning it won't be taken away. You actually own the stock. So if your stock is vesting, you don't really own it until it has vested, even though the grant looks large. What they refer to as the schedule is the total time period over which the stock vests. So it might be over 3 years or 4 years or 5 years, and it will vest on usually a quarterly or a monthly basis. So you'll often hear 20% equity, vesting monthly over 4 years with a 1-year cliff. The cliff is basically the initial time period that must pass before any of the founder's stock vests. So even if, for example, even if you're vesting quarterly over 4 years, if you have a cliff, you don't vest during the quarters of that first year. So just a really short example of the hovercraft business. If Sue agrees to receive 40% of the company's equity in the form of restricted stock that vests monthly over 4 years with 1-year cliff, that means that after the first, she won't vest anything in the first year, and then at 12 months, she'll actually vest 25% of her stock. So she'll own 10% of the company. Every month after that, for the ensuing 3 years, she'll vest 1/48 of her stock. We like to joke that vesting saves friendships. You don't have to read the paragraphs, but the gist of this as an example is that Nancy and Sue decide to start a skateboard hovercraft business, and they split it 60-40. Nancy gets 60% and Sue gets 40%. Nancy's working full-time, Sue's working part-time. She's fantastic. After 12 months, the hovercraft is ready to go to market. Sue has decided she got a promotion. She's decided to stay at her company. Nancy's going to run full time with this, but she really needs somebody to replace Sue to move forward. So, this really shows what a difference that vesting makes. So in a no vesting scenario, if they split it 60-40, Sue will actually continue to own 40% of the business. Nancy is forced then to dilute herself to attract additional talent out of her 60% she owns. If they had set up a vesting structure, then Sue would have only, after 12 months with a 1-year cliff, she would have only vested 25% of her shares. So she'll own about 10% of the business. That remaining 30% would go back into the pool, and then Nancy could use that to hire new wonderful people. I don't know if we can take if that's confusing at all. I'm happy to take any questions now, Connor, or to save them all until the end. You just let me know.
I think we'll take them to the end.
Okay.
Yeah, I think it's
perfect. So just talking about some other considerations, this is where structuring can be very sneaky. There are sort of standards for the different rights that are distributed among the sort of agreements that founders typically sign when they're starting a company. It's really important to understand what the document does. So many times people just read it, they assume it's legal mumbo jumbo, but this stuff can make absolutely huge differences. In addition to the vesting. So just to start very quickly with the notion of transfer restrictions. So oftentimes you'll see something in the agreement that says something like, the stock can't be transferred under any conditions unless, and then it'll have certain enumerated cases, like if the founder dies, it'll pass to their estate. If it's mutually agreed upon, et cetera, et cetera. The reasoning there is that if you're a founder, you don't really want your co-founder to go off and transfer their stock, because you might end up sharing the company with strangers, and that's something that you don't really want to do. You started the company with your co-founder for a reason. Secondly, the right of first refusal is very common. It basically gives other founders the right to buy stock that a founder is transferring, or gives the company the right to buy back the stock that they're transferring. So in the event that the founder is allowed to sell stock, let's say they say, oh, I've found a buyer for my stock at $10 a share, the company can swoop in and match that price to buy it back. Again, that's to prevent huge swaths of equity going to outside shareholders. Then repurchasing rights. are, they sound similar, but they're not similar. This usually takes place when somebody is leaving the company. So you'll often see within your stock restriction agreement as a founder, if you leave the company, then the company actually has the right to buy back the stock. For vested stock, it's usually, excuse me, for vested stock, it's usually at fair market value. And for unvested stock, it would usually just be at cost. So whatever you paid for that, whether it was, you know, a penny or $5, depending on the company valuation. This is the co-founders, again, want to just control who can hold on to that stock. Then there's board control and voting. This is often actually within the founders agreement. Usually you'll see founders who actually, founders actually set up the number of board seats, and the founders agreement will often lay out who can vote, who controls each board seat. And then you'll often see voting agreements within that founders agreement where you support you promise to support each other's choices with your votes for the board. This is to really protect co-founders, both from each other, but also from potentially future board members. Laying it out early sort of can prevent fights later on. The last very, very important structural consideration is accelerated vesting. That means basically that no matter what vesting schedule you set out, if certain events take place, then the vesting accelerates, and so you vest all of your stock immediately. If that, two common examples in founders agreements are acquisition of the company, or if you're fired without cause. So your co-founder, CEO, just decides to fire you, there's no cause, the company's not winding down, all of your equity vests, so you have the opportunity to continue owning the shares. That is actually found usually in the stock restriction agreement. In addition to founders, accelerated vesting used to be pretty common for employees, but no longer. Usually, you'll see in a stock option plan for employees specifically. Usually, accelerated vesting is not included, but co-founders often, still want these provisions in their own terms, of course, because they're putting their blood, sweat, and tears into starting the company. I should mention. I'm talking about all of this as stock. The most common sort of stock that founders get is restricted stock, which just means it's stock which is subject to restrictions like vesting, like transfer restrictions, etc. This makes, this is obviously operating on the assumption that the business you've started is a corporation which issues stock. Sometimes people prefer to incorporate as LLCs, for example. Those are, it's sort of, you can do similar things using those documents, but they're usually referred to as units instead of stock. So I just wanted to clarify that. I'm talking about it like restricted stock, but the actual form of the equity might differ slightly depending on how you incorporate. So moving on to splitting equity, I am a huge advocate of not splitting 50-50. And, the reason for that is that usually it's just the wrong answer. People usually aren't contributing 50-50 or 33-33-33. And you also really don't want company paralysis. So we talk to a lot of companies at Legal Hero, and we talked to company founders who split evenly, and we asked them why in the world they did that. And the answers we most often hear are, first of all, people say, oh, we want to avoid causing trouble. This is a difficult conversation. It's just so much easier. Co-founders have to talk about really, really tricky things. And equity is really just the very tip of the iceberg. So if you can't handle this kind of difficult conversation, it's really a red flag for what's to come down the road. The second thing we hear is, oh, we're all equals, so we deserve the same amount of equity. We're best friends from high school or college or business school. It's great. Well, the truth of the matter is that we are all equal as people, but we are usually not all equal in our abilities. And so, that really doesn't reflect the reality of the situation if we're honest with ourselves. The third reason we hear a lot is, hey, it's simple. I've got a lot on my plate. I'm trying to start a business. I really don't care that much about this. Whether it's 30 or 35% or 50 or 55%, it's either gonna, the total's either gonna be a big number or it's gonna be zero. So really, why should I devote so much time to this? It's lazy, basically. That's just the lazy answer. And you can end up in a situation where that sort of decision up front leads to a lot of trouble down the road. Lastly, you do hear people saying this, and this is often from co-founders who have worked together before, who are friends. We really want to make every major decision together. I mean, truthfully, that can just lead to horrible company paralysis. At the end of the day, you have to make really difficult choices. You might disagree on them. Giving somebody the ability, even if it's 51%, 49%, giving somebody the edge so that they can actually just make a call, whether it's a strategic call, or a capital raising call, whatever it may be, but so that they have the ability to make the call to move the company forward. That is hugely important. Company paralysis basically, usually means at the end of the day, the company is going to be worth zero. So, if you're not splitting it 50-50 or equally among co-founders, what factors should you consider? We at Legal Hero obviously have our own point of view on this, but I think the most important thing to consider is that you all agree on what the important factors are. So these are this is our list of factors, but if you and your co-founders think other things are very important, you should add that into your list and adjust the model we'll get to in a little while. So our first sort of point is, what role will each co-founder have in the business? CEOs usually get more equity because they're the ultimate decision maker. It's a difficult and high level of responsibility, so they often get a lot of equity for that. Other C-level roles also receive additional equity for taking on those responsibilities. Who's working full-time on the business? This is huge. If you've left your job and made an early commitment and joined up full-time to a company that really doesn't even exist yet, that deserves a ton of equity. Ideas obviously are critical. Who generated the business idea? What is this company based on? But really, so is execution. And in fact, execution is often so much more important than just generating the business idea. So did some co-founder actually take the step to build a prototype? Or to go out and market the business, or talk to potential customers, to potential suppliers, etc. Anyone who's really taking steps to validate the idea and execute on it, to lower your risk in doing this full time, should get more equity. We have an asterisk there because I do want to note that this is the time period where if you're building a prototype or other intellectual property for the business, but the business isn't fully incorporated yet, you have to make sure that each co-founder actually contributes that IP that they're generating to the business when they first start it. Oftentimes, businesses end up in a situation where they don't actually own the IP that they create because their early co-founders, just created it on their own time, and they're actually owned by individuals. So you really need to make sure there's pretty common IP contribution and assignment agreements, they're called, and that's what all co-founders should sign to make sure that any of those early sort of materials or IP produced actually is assigned to the company. Next is, if you're raising outside capital, is there one person who has access to the capital? One of your co-founders might be like a 5-time, serial entrepreneur who's raised a ton of capital and made a lot of money for investors out there. And that person is going to just have access to the capital, and you wouldn't get access to that capital without that person. They deserve a bump for that, for sure. Are there, domains of expertise are incredibly important when starting a business. So that expertise is really critical and should be noted. Contacts also, if you're have to line up suppliers and terms of those suppliers, customers, etc. This is something that, especially in enterprise focused companies, contacts are hugely valuable. And so that deserves special note as well. Who is critical to launching your product? Oftentimes you can't launch the product without somebody building the actual thing, so they should get equity for that. And who's critical to generating revenue? So, as we've learned recently, it turns out that all businesses do need revenues to survive over the long term. So if somebody's going to be out there that, is critical to generating that revenue, and more importantly, profits, then that person should get equity. So again, we're going to move into showing you our framework, but two notes of caution. One is, what's most important here is that co-founders really get together, agree on their own framework, agree on what's important, and commit to that, so that whatever comes out of it is something everyone is comfortable with, whether they end up with majority or minority of the business. You want all the co-founders to feel, to really back the decision that you make around equity. Second is, it's really important. A lot of times people fudge what I'll call sweat equity versus actual capital into the business. So sweat equity is basically, this is what the equity you're receiving for the work you're putting into the business. So for your past and future contributions, this is the equity that should vest, because it should keep you motivated to keep working and continue investing. That's called sweat equity. When occasionally co-founders will contribute capital directly into the business, so they're putting in $10,000 or $50,000. They should receive equity for that. That's not subject to vesting, right? That's just like any investor might put money into the business because they believe in it. That money does not vest, and should not vest. So to do that, when you consider, okay, splitting the equity is really about determining who gets how much sweat equity, and then separately you have to consider how the equity turns out based on what you put into the business. So having said that, the way we determine, our framework for determining sweat equity, I should say, we've decided, we basically went through and determined the most critical factors, which we just walked through. Each of those factors is assigned up to a certain number of points. Each co-founder is then given a certain number of points for each factor. And you guys will see what I'm talking about in just a minute. And then each of the co-founders' points are added up to achieve essentially their sweat equity sum. So that's their total sort of sweat equity points in the business. You take that and you divide it by the total number of sweat equity points among all of the co-founders. And that gives you a percentage sweat equity share. So if that was the end of it, if nobody was putting capital into the business, your sweat equity share would equal your total share in the company. Assuming somebody puts capital directly into the business, the trickiest thing must happen now. You actually have to assign a valuation to the business, a pre-money valuation. It's an incredibly hard thing to do. I have my own thoughts about sort of ways you can do it. It's untrue that all businesses are worth $1 million on day one, and it's untrue that all businesses are worth $0 on day one. So it's hard to get to the right number. When we're going through the framework, I'll give you my own thoughts on how to think about that a little bit. The value of each co-founder's capital contribution is then added to that pre-money valuation that you've determined. The sum is, called the post-money valuation. And then each founder who contributed equity basically receives, their share of equity equal to the amount they contributed divided by the post-money valuation, like any, other investor would do. So having said that, let me just switch for a moment. By the way, my email is annie@legalhero.com. I'm happy to answer any questions for you anytime. And let me just...
And Annie, I'll be sharing your contact details as well with everybody. So never fear, folks. You'll have Annie's email direct as soon as we wrap up today.
Great. All right. So I hope that you all can see the framework. Connor, can you see it?
Yep, you look great.
Great. So this is the co-founder equity split framework I was talking about. The yellow are all essentially input boxes, and then the blue at the bottom sort of determines the overall equity. And Connor, by the way, can share this with you all after the presentation as well. So if you want to futz around with it and enter your own numbers, you're more than welcome to. So first I'll start with this is really a demonstration piece, but everyone starts with 10 points for being a co-founder. In this example, we have 2 co-founders. Let's imagine one is we've got a non-technical co-founder and a technical co-founder, just for the purposes of our example. As you can see on the bottom, the way to read this is if you look down, you'll see that right now, because they each have 10 points, the company sweat equity is split 50-50. Nobody's contributing any capital, so there's no capital to be taken into consideration, and so their share of their total equity is about 50%. When you think about the pre-money valuation, I mentioned I talk about my own guidance for this. I mean, this is so hard. What the heck is a company worth before it has customers or revenues or profits? Or maybe it has IP, maybe it doesn't. Maybe it's just a great idea. It's sort of a tough call. One guideline I like to use is, what are you giving up to start this company, to do this company? So in this sort of example, I've assumed that each of these founders can make about $100,000 a year, and that they've each committed to spending a year on the business. And so it's not perfect, but the opportunity cost of what they're giving up to start the business with their year-long commitment is about $200,000. And so that's what I've assigned in this hypothetical example as the pre-money valuation. I really think that's one sort of imperfect but sort of practical way to do it is considering your opportunity cost, or the total opportunity cost of all the co-founders. Now, if you have IP and other things, you can add up the value of that IP potentially instead. So everyone starts with 10 points. So in this case, let's say founder 1 is the CEO, and that's 10 points. And then let's say founder 2 is the technical co-founder, and that person's going to be the CTO. So CTO is going to get 5 points for that. Now, full-time employees get 10 points. This is so important. In this case, let's imagine the CTO has given up her full-time job to go pursue this. So she's going to get 10 points. The CEO is still working part-time on their previous business, so it's 0. Okay, so as is often the case in these situations, let's imagine that, the CEO, the sort of non-technical co-founder actually generated the idea, thought it up one day randomly. And so, but then, well, let's call that an 8 because CTO then came in and had lots and lots of valid points, and so contributed on this front as well to sort of tweak the idea. So 4. I should mention you can get up to 10 points. These things don't need to add up to 10. So, for example, here, obviously I gave one co-founder an 8 and the other co-founder a 4. They can add up to more than 10, but you can't give any co-founder more than 10 points. So, before all of this started, the CEO went ahead and actually built a small prototype and, based on the original idea in order to validate it and de-risk it. So let's give that person a 10. And the CTO gets a 0 here because she wasn't part of that process. And, let's say you're raising outside capital, you might have 5 points for the access to actually fundraise. The CEO is super connected, but the CTO also knows a few angels and VCs, so give them points. So who's the expert in the industry? Let's say the CEO is the expert in the industry and the CTO is really new to it. The CEOs will also have the contacts, given that they're the expert. Critical to launch, yeah, they might have to set up a few test customers and things, so let's give them a 3, but we really need the technical product to be top-notch, so we'll give the CTO a 5. And then generating revenue, it's kind of the opposite. We need the CEO and the CTO get a 3. So in this case, The CEO has 61 points, sweat equity points. The CTO has 40 sweat equity points. So their share of sweat equity comes out to about 60-40. This is assuming, and as you can see down at the bottom, their total share of total equity is also 60-40 because there's no capital contributed. Now let's imagine that the CEO is going to put in $100,000. And the CTO is not putting in any cash. This really changes things pretty drastically because you'll see now that based on the valuation of the company, which I had set the pre-money valuation, $200,000, now there has been $100,000 contributed, so a post-money valuation of $300,000, meaning the CEO, just based on the capital investment, owns 1/3 of the company, just out of the straight capital. So that's where you see down here, 33%, and then 0% for non-sweat equity. Now the sweat equity percentages will have changed considerably because that is out of the sweat equity is basically based on the pre-money of $200,000. So instead of being 60-40, it's about 40-26. When you add up the sweat equity and the non-sweat equity, the CEO's total will be about 74%, and the CTO's total will be about 26%. The non-sweat equity is based on the value contributed divided by the post-money valuation, and the sweat equity is based on the total number of the sweat equity points that you have earned, divided by what percentage of the entire business the sweat equity percentage makes up. So in this case, 2/3. So that's sort of just a quick example, just to show you the math and how it's set up. What's interesting about this is, if you believe other factors are important or really don't believe these factors are important, we've set it up as an actual spreadsheet that you can manipulate. So be careful, don't mess up any formulas, but if you want to change what the factors are or add some factors, it's pretty easy to do that so that you can have your own model. And again, I would just emphasize the importance here of just agreeing to the framework and then committing to what the results are. Yeah, so that's basically about it. I'm happy to take any questions at all. On structuring or splitting or the framework, anything you all want.
That's brilliant. Thank you so much, Annie. What a great introduction into this topic. I hope for everyone who's been watching that this has generated some questions for them. So first, I should mention, we've had a few questions come in already, but if you are using Google Hangouts, you're watching this on air, just enable the Q&A feature, which you can do by going to the top left corner and selecting of your screen and selecting Q&A. From there, you'll be able to enter a question. And in fact, just to quickly answer Pratik's question, this will be available online on YouTube afterwards, and I'll be sending out the link as well as posting this to the community portal, so you'll be able to find that, no trouble. But so one question that we have is specifically about technical versus non-technical founders. I think, and I guess this is probably coming from the fact that we often here at SOSV really talk about the essential need for a technical co-founder. But essentially, is there ever a time when the CTO would have more of an equity stake than the CEO? And I think I can probably myself think of a couple answers, specifically with capital contributed, but maybe are there other ways to weight factors that would maybe put the CTO over the edge, or is in your experience, maybe in the long-term longitudinally, is it almost always the case that the CEO would have the greater equity stake?
I actually don't think that that's always the case at all. Of course there's capital contributed, but since I'm on the framework, let's just see what happens here. It's not so much about, non-technical versus technical, but also, these considerations. So, for example, let's imagine this is all the same, but let's imagine here that the CTO actually generated the idea and, went out and built a small, prototype to sort of test it and realized, geez, I'm really onto something here. and I need to go out and sell it, but I don't really know how to sell it in the business, and so I need somebody to do that for me. Just switching that, the CTO is the person who came up with the idea and took steps to validate it and brought on the non-technical co-founder afterward. Just that in itself, looking at the sweat equity, if you were to take the capital away, if you just look at the sweat equity, I mean, that's an example right there of the CTO getting the majority of the business over the CEO. So definitely those cases absolutely exist. And sometimes, the technical co-founder actually becomes CEO of the business over time. I think Mark Zuckerberg is an example of that, right? He was the technical co-founder of a business, but he was really the guy running. Of course, if the CTO is going to end up, running things, if the technical founder is end up running things, they'd end up in the CTO. The non-technical co-founder might be, head of business development or something like that. That skews the equity even more in favor of the CTO. So it really just depends on the individual circumstances.
That makes total sense. We have another question here about what do we do if we've already essentially split our equity? So we're already 50-50. What can we do, in a later state to kind of recalibrate?
Yeah, that's actually, if you're both in agreement in terms of recalibrating, it's not too difficult to do. Basically, you're just gonna, depending on how much equity you actually issued to the two founders, and how much you had authorized. So the way companies work is, you have an amount of authorized stock, let's say 10 million. Shares, and then let's say you issued 5 million already and you split that 5 million 50-50. In order to recalibrate, what you could do is just issue more shares, anything up to that 10 million number, to get the percentages that you want. And of course, there are legal agreements that go along with that. And if you split it 50-50, by the way, and none of that was subject to vesting, you should definitely consider really actually diluting yourselves down by issuing a lot more equity, and making the portion of your equity that's already vested a small portion of the business in order to make most of it vesting, if you're in agreement. I should mention too that if you're going to go out and raise money from institutional investors, they will require that you vest your equity anyway. So they're not going to be happy if you've issued yourself. They're going to force basically the same mechanism where your current stuff is diluted down to vesting.
Perfect. Okay, we have another question about, well, I guess this, I don't know if we already talked about this, but we should dive into it. What is the best time to establish an ESOP pool? How do we go about doing that? And what are the necessary steps for equally setting aside equity there?
Sorry, was that for equally setting aside equity?
Yeah, for submitting, for creating an ESOP pool in a way that is equitable to, I guess, future employees. It must be.
Yeah, I think I'm an advocate of doing this pretty early because it's just nice to have a pool of equity that's available to option. I should say the way mechanically it works is pretty boring. It's a lot of legal stuff. So you usually set up essentially what's an employee stock plan. That's a legal document. It's usually a pretty hefty one. It lays out all the rules. It has in terms of what kind of options are they, what are all the sort of structuring considerations we talked about. What are the transfer restrictions? What happens when an employee leaves the company? Can you buy back the options? Do the options disappear? What forces how long do the options last? All of that stuff is generally held within this document. That's the employee stock option plan. And that has to be approved by shareholders of the company. And then each, that document also, that document along with, I should say, the board what we call, this is really legal technical mumbo jumbo, but that document in conjunction with the board consents or board meeting minutes. It's basically an action of the board to set up the stock option pool, set aside the stock for it, and sort of determine the rules of it. That's all set up, and then each individual employee who's coming on board receives a document that's essentially a stock option grant. If you're issuing stock options, that lays out the specific terms for that. So that's what includes their vesting, their cliff, the number of options they receive, etc. So it's sort of those two documents. The stock option grants obviously go out individually to employees as they're made offers, and every time an employee is issued options, the board has to approve that. But the stock option pool is like sort of the big structural setup you have to do for the business in order to be able to issue options. If as soon as you're thinking about bringing people on board, or as soon as you're committing to bringing people on board, employees, I'm an advocate of doing that as quickly as possible. Mostly just because equity is very attractive to people, and you want the type of people who are attracted to equity. So you want to be set up in order to be able to issue it.
Brilliant, thanks. We have a question here from Jin. What if one of the co-founders, and you talked about this a little bit, what if one of the co-founders is leaving the company? Does the founders agreement trigger at this point? Does the startup buy back the shares automatically, or will we need to hire a legal firm to deal with it? That seems like a big question.
Yeah, no, definitely. So let me go back to the presentation, which I think will help with this. Usually, so this is the page I'll go to. Usually when a co-founder leaves the business, that will trigger a repurchasing rights. So there will be, let's say the co-founder, if the co-founder's been issued restricted stock, and then they leave, before all of that has vested, usually you'll have some portion that is stock that is fully vested and some portion that is unvested. The agreement that the co-founder actually signs, the stock restriction agreement, will usually lay out the terms where if they leave the company then has the right to buy back the stock at the specific prices. So if you vested, they have to usually buy back a fair market value. And if you haven't vested, then they have to buy it back at cost, whatever you paid for it. Usually the company will have a certain amount of time to do that. And the document, the stock restriction agreement itself, will lay that out. And you don't, that's not something I would say, if the stock restriction agreement is laid out, that's something that hopefully, you won't require a lot of you won't require to spend a lot of legal time on it. That being said, it's always good if a co-founder is leaving to have them sign a small document, just take again that they're leaving and they're selling back the stock in accordance with the agreement that they signed and stuff, just to make sure, if there's ever a situation where you think, people might remember history differently, I'd recommend documenting it. It could be that when you start the process, you can have a lawyer draft something that you can use for any co-founder leaving in the future.
Great. I also like that term, remembering history differently. Very diplomatic. Great. Thanks for that question, Jin. We have a question now from Vasily, who asks, if a co-founder during the vesting process loses energy and did not generate value for the company anymore, is it possible to put a pause on his vesting, and how do you do that?
Oh, that is a great question. You don't really put a pause on. I mean, you've agreed to the stock at the vesting. You have stock restriction agreements where, like, if they take a leave of absence or something like that, it puts a pause on the clock for vesting. But you can't. I don't believe you can unilaterally just sort of pause their clock as a stick, if you will. Yeah. Vesting is more of something to be used as a carrot to be motivated, not as a stick to be measured. So if a co-founder though slows down and really isn't pulling their fair share of the weight, I mean, that's the whole reason vesting exists, so that you can have a serious conversation about whether or not they want to move on from the business. And hey, if they think I need to take a break for 6 months, I can't do this, you know, what you can do is have them leave the business, you know, give up all of that unvested stock, you know, get it back at cost, etc. Have them walk away, and then, you know, come back to the business in the future, and at that time, whenever that, you know, end round agreement at that time as to what's appropriate. A company, even if somebody steps away for six months, a company at early stage can look radically different 6 months later. So, you know, a different agreement might be in order.
Perfect, thanks. And we have another question from Julia, who asks, how much of a role does equity percentage play in the salary of co-founders?
Oh, I think that's a really great question. You know, I think, I think that's a really great question. I actually should have mentioned that before. You know, oftentimes you have co-founders who just really care about different things. You know, some people, or just have different sort of financial needs. Some people really, you know, they don't have income coming in from anywhere else, and they can't, they're not, you know, they need to eat. And so they're willing to forego, you know, equity for that cash payment. Other co-founders might say, hey, you know, I'm worth $150,000 a year, but, you know, I've saved up a lot of money. I really believe in this company. I'd rather take a salary of $30,000 and take, you know, the rest of that in equity. I definitely think that's part of the negotiation when you're thinking about how to split it, is, you know, play that, you know, think about what the value of the equity is based on what you think the company is worth on the pre-money valuation. And you might just want to adjust things up or down. And by the way, I think that's true with employees as well. You know, I remember hiring somebody once for Legal Hero, and during the salary negotiation, I gave him the option of, you know, a slightly higher salary with less equity or a slightly lower salary with more equity. And, you know, as a founder of a business, you can't be more excited when somebody chooses to give up cash for equity in your business, because you know that that's a person who really believes in your business. And so it also tells you things about people's motivation and sort of what they, you know, once you sort of get over the threshold of feeding yourself and making sure you're dressed and have the needs, you know, to meet life needs, anything beyond that, you really get a sense for their trade-offs in terms of what they think the company might be worth in the future.
Really good answer. Thanks for your question as well, Julia. We have another question about stock buybacks. It seems to be coming up again and again. This question is from Pratik, who asks, should the vested stock be bought back at the time of co-founders leaving the company? We've heard a bit about dead capital and that investors don't want to invest in a company with dead capital. So should the vested stock be bought back immediately as well when a co-founder is, and what if the company doesn't have enough money to buy it back?
Yeah, you know, and that is always the tricky thing. Oftentimes the companies have the right to buy it back in the repurchase rights. Sometimes the company has enough cash. Sometimes, you know, if the co-founder leaves, it completely depends on the circumstances, right? Because imagine a scenario where the co-founder is leaving on really negative terms. Mm-hmm. And you might think, oh, the company wants to buy back that stock, but and get this person out of the picture. However, having them hold on to equity actually might, you know, give them the motivation they need not to badmouth the business or to badmouth their co-founders, because that equity in itself can grow to huge value. So, you know, could be that you really want the person to still have a stake in the business. So you want them walking around with a little bit of equity. You especially want that if they, you know, have sort of a big presence in the world, any, you know, sort of a celebrity or a major celebrity or a minor celebrity that might bring, you know, users and customers to your business. You might want to leave them with some cash. If you know, when you're buying back vested stock, you have to buy it back at fair market value. If you don't have the cash to buy it back, then that's just an unfortunate reality for a lot of businesses. So, you know, hopefully though, you know, just the people having a small stake in the business at that point will get them to say really nice things about the business all the time and provide you with value that way.
Great. It's so funny that these questions keep coming up time again. It's like this must happen. It must happen more than never.
I think buying back stock, and I think, and sometimes you really just want to buy back that stock. You want to be out of that financial relationship. And so if you can, and you believe, maybe the person doesn't think the business is going to be that valuable, so they want to be bought out. And you want that stock back in for motivating, current and future employees. So it's important to think really carefully about what makes sense in your given circumstance. Unfortunately, there's no sort of a one-size-fits-all rule for that.
Of course, yeah. And thanks for that question very much, Pratik. Okay, so we still have a little bit of time, so if you want to drop some of your questions into the Q&A app, please do. But otherwise, I always have a question that I like asking founders like yourself, Annie, which is basically, what are the three, let's say three, or you can make it as long as you're on the list, but what are kind of the top mistakes or maybe tips you would give? What are the top mistakes that founders make when it comes to equity splits right off the bat, maybe especially early stage folks, or maybe what are kind of three immediate lessons you would kind of say to this right now?
Yeah, I think, gut reaction, I think, number one is that equal distribution. I can't tell you how many people I know have been burned by splitting a company 50-50 and then having disagreements and just literally being frozen, because if you own 50% of the company and you need 51% to do anything, you can't do anything unless you're in agreement. It's not a good place to be when you're in disagreement. So in those circumstances, a lot of times the companies end up sort of dying before they really get off the ground. That's one example, or one major thing that we see. The second is actually not documenting stuff, so there's a time period where, of course you don't want to spend the money on lawyers to document things. It absolutely, it doesn't make sense unless you're sure you're really going to move forward. But once you've sort of determined the split and agreed, hey, everyone's going to be subject to vesting and, these types of restrictions, you really want to get that to paper as quickly as possible, because again, you can be lazy. You've got a lot of things to do. Nobody wants to think about the legal nonsense, especially when you're out trying to build a product and get customers and suppliers, and you're just absolutely running around promoting the business, but not writing the stuff down, not getting it documented. That's what really leads to situations where people remember things very differently, and they remember history differently, as I said earlier. So you'd be surprised by how far businesses get before this kind of stuff is documented. And investors don't like everyone wants to know, including investors, that all the co-founders are on the same page about the equity in the business and their share of the equity in the business. So cleaning up those mistakes down the road is just hugely expensive. And then the last thing I'd say is actually, it's sort of similar to documentation, but different. Don't be afraid to get advice about this from both, well, I'd say both lawyers, but also other people who have started companies. There tends to be a lot of people because if you own a significant stake in the company, it can be a significant part of your net worth. And so people tend to be pretty tight-lipped about, their own approaches to splitting equity, how much they ended up with. It's shockingly difficult to sort of get people to really open up about it. But do keep asking people and try to return the favor and give your honest thoughts when, future founders ask you, because, it's hard. It's sort of a vacuum of information, and it's hard to operate. And so try to get as much information as you can about what has worked and what hasn't worked, and what the splits look like, bad structuring situations, etc. I think knowledge is key here, and talk to a lawyer if possible, because they're the ones who see a lot of the stuff that goes wrong. So when you're documenting, this is a situation where I wouldn't just pull down something from the internet. I would actually get a lawyer to do it and to talk to you all, make sure that everyone understands what they're signing, and make sure that you've sort of gotten all the considerations under control in your own money.
Right, those are great tips, and I would just maybe add for our SOSV teams, you can always email our legal office or the back office guys who handle legal, for advice. Not that we are, we're working with hundreds of different companies in different countries, but certainly, as a starting point, you should also really feel comfortable asking these kind of questions in the various forums we have for you in the community portal as well. We have one more question. I think that's what I'll have time for. From Pratik again, thank you. Are there any other important documents that a company should have at the beginning when you're founding a company, apart from the founders agreement and the restriction stock agreement? And I'm gonna say probably as it pertains to equity.
Yeah, I should say, it's really when the other major agreements are the IP contribution and assignment agreement that each co-founder should sign. I mentioned it early on. That usually just means that any IP you developed in the course of starting the business now belongs to the business. You're contributing that in exchange for some equity that you're getting. So there's that, and that will often also include a non-compete as part of that, non-compete, non-solicit, to make sure that co-founders won't break up and you won't go and sort of start a competing business the next day. That's usually done, all of this is often done in accordance, in conjunction with incorporating. So, I'm just going to use the most common world as an example, but a lot of startups are incorporated as Delaware C corporations. That will include about 5 sort of Delaware-oriented documents to start the business, a certificate of incorporation, some sort of board documents, bylaws. When we say founders agreement, by the way, another word for founders agreement is shareholders agreement. Founders agreements are just used in the sort of startup world as that's what they call shareholders agreements, but it's really the same thing. And then of course the stock restriction agreements and all the contribute. So anything you own that you're putting into the business, there has to be a contribution agreement for. That's the other main thing. And then of course the non-compete stuff I mentioned. So yeah, I think that's, those are the sort of the main documents that you have. And if you're starting with co-founders, you'll definitely be doing that right away.
Perfect. Thanks very much for that recap, Annie. So I think that's all we have time for today, folks. Annie, thank you so much for taking part today and sharing all of this knowledge and walking us through, all the kind of expertise that you have in this field. Like Annie mentioned, I'll be sending along your own copy of the equity split calculator, so you should all feel free to play around with that. I think you mentioned at one point, Annie, that you have founders normally do it all separately and then come back and do some comparing and contrasting.
Yes, I definitely recommend that because not only does it get you to a fair place, but it also gives everyone a sense for how they perceive themselves and everybody else in the business.
So great chats ahead for all of you. So Annie, thank you very much. I should also mention too, just before we go, that we have a great deal in place with Legal Hero where any team from SOSV can avail of 10% off any fixed service fee or fixed fee service. So you should certainly check them out in the community portal. If you like what you heard from Annie today, there's more of that available for you guys. So certainly feel free to check out Legal Hero. They're doing amazing work and have tons and tons of knowledge and can set you up with tons and tons of awesome attorneys. So it's a great service. So, anyway, thank you so much, Annie. And again, everyone, thank you all for taking part.
Thanks, guys.